When Alan Jackson made that statement that, according to the laws of the state of California, Nick Reiner is not guilty, and he emphasized that, of murder, my read on that was that he was sort of alluding to an insanity plea.
Nick Reiner will have an uphill battle to prevail on an insanity defense in California. Even though it's a little better than my jurisdiction, it's still a pretty tough road.
Hello and welcome to the Dr. Suzette Glasner Podcast. Today I am joined by Nathan Lockwood, private defense attorney in Pennsylvania and former public defender in Alaska. He has been doing trial work for more than a decade, which in a small town can mean working with defendants whom you've known for years. Mr. Lockwood has extensive experience representing individuals who committed violent crimes, including homicide. His practice for the last 7 years has been focused on serious cases, including homicides, sex offenses, and kidnappings. And after securing an acquittal in a double homicide case in Alaska, he won the Champion of Liberty Award in 2024. I had the opportunity to learn from Mr. Lockwood's expertise in understanding criminal responsibility firsthand when we collaborated on a case involving attempted murder in the context of methamphetamine use and psychosis. Welcome, Nathan, and thank you for being here today.
Thank you.
So I want to just start a little bit on your background. Can you tell me a little bit about your background and professional experience?
I got into criminal defense just because I think ideologically I'm more aligned with the defense than I am the prosecution. That's not to say I don't think that both sides have an integral part to play in the system. They do. We need competent prosecutors and we need competent defense attorneys so the system just runs right. But for me, I wanted to pursue a career that had me helping people. And I know that if you ask the prosecutor, they would tell you that they help people. But I feel the effects of what I do on an individual basis with people that I help. And I've never had a case, no matter how bad it is, where the person didn't need some help. And I've been gratified and honored to be able to do that for the last 13, 14 years.
Yeah, so it sounds like there is like a very rewarding aspect of what you do. And when you say you've never worked on a case where they didn't need help, do you mean in the sense of managing the sort of legal burdens and all the stress that creates, or do you mean more broadly around their mental health?
Often it is just helping them navigate the criminal justice system and getting them the best result that I can. But you aren't in my office because you have had everything go right in your life. So there's a reason that you need my help. And maybe it is just, the legal advice, but more often than not, the people who came through my door as a public defender have had not just trouble in their legal life, but in their life in general. And as we worked together on a case, you saw, and I'm sure you've seen through your work, that often criminal actions go hand in hand with mental health and substance abuse issues. But for those issues, they would not be in my office or in a jail cell. They would be living the same life that we all do. It's been pretty striking to me in my career to see how easily a person can get knocked off course. And if I can help them in some way legally, or maybe even in their life a little bit, because a big part of being a public defender is doing social work. If I can help them in any aspect of their life, that is a win. And as a public defender, you have to find your wins where they are. They're not usually full acquittals. It's not getting your client free. It's making their life hopefully a little better, getting a little better outcome, hopefully addressing some of the issues that they're going to have through incarceration, through their release. If it's, just sentence mediation, that's something that I can, mitigation, that's something I can help them with. And that makes a impactful difference in their life, even though it doesn't open the doors and let them out, as they say.
Yeah, it's really interesting the way that you frame and describe the rewarding aspects of your career, because I don't think legal work as a defense attorney is necessarily viewed traditionally as a helping profession. My profession is very traditionally viewed that way. Anyone in the healthcare profession is viewed that way. But the way that you describe what drives and motivates you sort of leads me to categorize your profession as very similar in terms of driving, motivating forces and rewards at the end of the day to mine.
Yeah, I've seen that overlap quite a bit. I likened it to social work. It's a big aspect of our job, and working hand in hand with mental health professionals, substance abuse professionals, medical professionals. It's striking how similar our, maybe not our day-to-day jobs are, but our guiding philosophies of what our jobs are. Right, it's to improve the client's life in any way that we can through the tools that we have in our job. Right, your tools are very different than mine, but the goal is essentially the same thing: to improve this person's life.
Yeah. Thank you for that that perspective. What would you say is the most challenging aspect of your work?
The term secondhand trauma is one that we use a lot in our profession. I would say it's just dealing day to day with really bad outcomes for everyone. You know, it's the victims in the case that always has an effect. I think that defense attorneys are not usually seen as caring about what happened in the case before they took over and started helping their client. But dealing with the trauma of just processing the acts that you are defending your client from, the impacts that you hear every day from the families. Sentencing hearings, for instance, are very emotional because the victims come in and they're talking directly to your client, telling them how their lives have been destroyed. But I would say that the number one thing that has devastated me, brought me to tears, is watching that client that I fought so hard for go away. And, now at the level I'm at, for the rest of their lives, usually, they're not going to get back out. And it's hard not to feel like you didn't do enough when they go away, no matter how bad the cards were that you were dealt with the case, how, strong the state's evidence was against your client. Still very, it's very hard to watch them walk through that door, which is what happens. They walk through that door and you know that they're going back to prison forever. And that is devastating. No matter what the crime was and no matter how bad you thought your case was, it just really never gets any easier.
This is not a well-known perspective for most of us watching high-profile trials or proceedings. We always view the defense attorney as kind of a rock who is determined to affect a certain outcome and is maybe not sensitive to the rest of the context of what the other family members are going through and how everyone is impacted by the outcome, whether it's optimal or not. And I really appreciate that kind of psychological insight. And also, it brings me back to this analogy with the helping profession. What went through my mind when you talked about what happens when they walk away was what it's like as an addiction expert working with individuals and families who struggle with substance use and addiction and seeing them relapse. And sometimes one relapse can be fatal or very devastating or can have some really serious consequences for a family. And I think we professionals, even though we know that addiction's a relapsing illness and that this is part of the course. I know I can say, from my perspective, I know that feeling of what more could have been done, even if logically I know that this is part of the illness. When you take your work really seriously and you're committed to it, it's hard not to take it personally when things unfold in a way that are not good for the individual or the other people in their life who are affected by it.
Yeah, I think it is hard for outsiders to understand. I think that's a thing that public defenders share with mental health and substance abuse professionals. That when you sit down with that human being, right, you can't help but, one, you develop a relationship with them, right? But two, you get to know them, right? And I mean, not to be too hokey, but to know someone is to love someone, right? And I'm not saying that those feelings develop that deeply, but you care about the people that you work with, right? Your clients. And even if they are the most difficult people on the planet, which they quite often are, just seeing their struggles, seeing them struggle with themselves, and just not having the power to change that for them is very hard. And you mentioned that defense attorneys often appear to the public to be a rock. That's our job. Like, our job is to stand there and to be strong for our clients, to never let any emotion show through that could hurt our clients' chances, whatever chances we think they have, right? If it's a chance to get a good outcome through a plea, or a chance to get in a good outcome in front of a jury through a trial, the way you present yourself in that courtroom is very important to the outcome that your client gets. So that it does create this perception that we just don't care, right? We don't care about those victims over there, and we really don't care about what happens to our client. We're just moving the widgets through the machine. And that couldn't be further from the truth. I know that I am not anomalous. I'm not an outlier with how I feel towards my clients. I work with people who care just as much, sometimes more than I did, about their clients. And that seemed to be more the rule than the exception.
Well, I think that ties to something that I was going to start to delve into next with you about the Nick Reiner case, which we're going to get into for a good portion of our discussion today, which was I felt like I saw some of that in Alan Jackson's statement when he spoke with the public about withdrawing from the Nick Reiner case and having it reassigned to a public defender. And the way he spoke about Nick and about how committed he continued to feel to Nick and his best interests, and how passionately he spoke about his opinion about Nick being not guilty by the laws of the state of California. I felt in that moment like this man seems connected to Nick Reiner and this whole case in a way that goes beyond just, investigating and working on it from a legal perspective. It felt kind of personal, and all that you've described up until now about what it's like to represent somebody in this position is reminding me of that a bit.
Yeah, I saw that statement as well, and my first impression was that is a pro. That is an excellent presentation of your announcement that you have to withdraw from the case. And it's not always the way that attorneys in these high-profile cases exit, right? They don't always do it with grace towards their client. And I thought that showed a lot of grace to the client, and also continued to vigorously present what is essentially their defense, that Nick Reiner is not guilty under the laws of California, which I thought was an interesting way to put it. I thought there was a lot in there. But my overall impression is just that is exactly how a defense attorney should present themselves to the media. Did not seem like that was for his professional benefit, but for the benefit of his client. And that should always be the way that we present ourselves to the public, that it is our client who is important. We essentially don't exist aside from being a mouthpiece, a voice for our clients' interests. And I thought that was a great example of it.
Yeah, very professional. And there's been so much speculation around what the defense strategy is going to look like. I've seen on other podcasts and shows people talking about not guilty by reason of insanity. And certainly when Alan Jackson made that statement that according to the laws of the state of California, Nick Reiner is not guilty, and he emphasized that, of murder. My read on that was that he was sort of alluding to an insanity plea. But I wanted to spend some time unpacking that with you a little bit to see if that was your impression and your interpretation, or if you saw this through a different lens.
I think that is, you can definitely read in there that the insanity defense is coming. That I think that's a pretty fair interpretation, even from other attorneys. But I know that it's also pretty early in a case to be deciding what your defense is going to be. And I do know that he will have, Nick Reiner will have an uphill battle to prevail on an insanity defense in California. Even though it's a little better than my jurisdiction, it's still a pretty tough road. So I'm guessing that's where he's going, but it is just an educated guess at this point. But what he said to the media certainly does support that defense. But I mean, it's also wide open under the laws of California, right? Anyone who didn't commit the crime, right, wasn't there, is innocent under or not guilty under the laws of California. I think I left it open for other defenses, but I think it's signaled to the media that insanity is definitely on the table.
So maybe you could help me unpack sort of the non-guilty by reason of insanity plea and what it actually means. I know that varies by state to some extent.
Well, so Alaska, where I practiced the majority of my career, and California both follow what's called the McNaughton rule. It's a very old rule. It actually comes from we're a common law society, which means our code was taken from England, and McNaughton is actually a case from England. I'm not sure the date, but long before our criminal code was written, where it was one of the first insanity defenses run. McNaughton apparently tried to kill the prime minister, but was insane. This is the nomenclature at the time, right? And didn't appreciate the wrongfulness of his conduct, right? Which is sort of the underpinning rule that guides the McNaughton standard, right? Whether the person appreciated the wrongfulness of their conduct. It is a very controversial defense, always has been, and limit what can happen if you're successful with it. So the McNaughton rule, which is said is in Alaska and California, it is now, I think, the majority rule around the country. Each state adopts their own. Some states completely have banned insanity defenses, and the Supreme Court has actually upheld that you can, as a state, totally eliminate the defense. Alaska has become one of the hardest states, which I alluded to earlier, in running an insanity defense. California is a little bit better from a defendant standpoint. For an insanity defense, you can try, but you'll lose, right? So in California, they do allow for delusional behavior, which does not allow you to appreciate the wrongfulness, the moral wrongfulness, not the factual wrongfulness. So someone who has delusions, who say believes that they are saving someone, they're wrong, but they're saving someone by killing another person, right? They would be allowed to run that defense and convince a jury legally that their client is not guilty by reason of insanity. Then you get into what happens to them next. And both in California and Alaska, essentially the person is committed for mental health treatment. up to the maximum period of incarceration allowed for the offense for which they were tried. So if Nick Reiner is acquitted in California under this insanity defense, does not mean that he will walk out the door. It means he will be committed until he's cured or he's served the entirety of his sentence, right? I imagine in California they have the same type of hearings that we do in Alaska, where we are checking in to see if this person has been cured, which, as a mental health professional, I know that you know that is a very loaded term, and when placed in the hands of non-mental health professionals, that term can and does keep these people in custody essentially until they've served their sentence. And in Alaska, it is maximum 99. In California, I know that they have life, so you can see that is essentially a life sentence. Although it is not presented that way in the media, certainly, and I think that's part of the reason that insanity defenses around the country have become so insane, excuse me for the pun, but they don't really allow a path for someone who does not have the ability to form the mental state, or the mens rea, to use the Latin, to commit the crime. They don't allow those people who have a mental disease or defect to actually escape punishment, which is what I think the media always packages it as, that this person is claiming insanity, so they are essentially trying to get off for what they did, trying to get away with it, which if you knew what happens to them afterwards, you wouldn't think that, right? And those were always my decisions in Alaska when I was presented with these cases. Is the case so bad for my client that I just want to aim for getting him into a better cage, right? A cage that will provide him mental health treatment, hopefully. One that won't have him in constant danger every day because he is severely mentally ill. I keep saying he, it's they, it's anyone, right? But they're so severely mentally ill that they're at risk in custody. And while the Department of Corrections nationwide has become the #1 mental health provider, that is by quantity, certainly not by quality, right? They, through some societal changes that we have made, we have eliminated a lot of institutions, and I think that the reason for that was definitely laudable. I mean, we saw what was happening in mental institutions, and we had a hard reaction to it. And we've essentially eliminated that mental health treatment. And that means that who's picking up the slack? It's DOC. And I'm not knocking everyone at DOC. I just don't think that they are mental health professionals, so they are not providing the level of care that these people actually need to be cured, for one thing, and also just to be stable and safe.
Yeah, you bring up a lot of great points. I have heard that mentioned in a variety of places around the magnitude of the mental health treatment that's being provided in correctional settings.
You do have some options in California, and I would assume that their system is better because of it. But these systems, these institutions are maxed out. They are overcrowded, just as our jails are overcrowded. And they are very difficult places to work. So it often means there's a lot of turnover, and unfortunately it also means that there are times when the quality of the professionals that are working there is not high enough to meet the standards that we would all expect. So I'm making it sound pretty bleak, because it is. Once mental health gets involved in a criminal case, you would think, talking media, that outcomes become better. They generally become worse, in my experience.
So where's the best place for somebody with severe mental illness who's committed a double homicide? Like, what do you think would be
best?
The best outcome for someone in that scenario?
Well, I obviously they vary greatly, right? Depending on the offense, the person's mental illness. But quite often for me, it has been trying to get a plea deal that acknowledges their reduced culpability. but not pursuing an insanity defense. That is usually the way I have gone in cases where the best defense is my client did it, but we should excuse his conduct to some degree because he was suffering from mental disease or defect that affected his ability to appreciate the wrongfulness of his conduct, right? I'm using all the language of the insanity defense when I'm talking about it, right? But the goal is hopefully to get this person a reduced sentence, right? And try to get them out, right? And out for them will still mean out supervised, parole, probation, mental health treatment. But I have seen the best outcomes for my clients who have severe mental health issues is to get out and get help through professionals on the outside. Mm-hmm. You don't want to have to rely on these lockdown institutions to treat people because they are overworked, overtaxed, and often they are staff of people who could do better, right? And that is not a knock on people in those institutions as a whole, but I think that the pressures that are placed on those mental health professionals make it a job that's hard to stay in. And when you have a lot of turnover, you end up with people who maybe should go, right? Because they no longer have the empathy to stay at it. Yeah. And the empathy well is a finite resource for every mental health or public defender, right? Or substance abuse provider. That empathy well is something that if you run dry, you need to get out.
So what would you say to the sort of, I think the general public view of this approach to a reduced sentence and getting them better quality care out in the real world outside of a correctional facility is like, well, that's a threat to public safety.
I understand where that comes from. I understand the inclination to be afraid of someone who has done something horrible. I think first, an acknowledgement that getting a reduced sentence does not mean that they are out tomorrow. Someone who's getting a reduced sentence for a homicide, say they're charged with murder 1 and they get reduced to murder 2, they're still probably going to be looking at 30 years. Seems to be the going rate in Alaska right now for a plea for murder 2.
Wow.
And the range goes from 15 up to 99, so there's a wide range there. No one gets the minimum, right? Even though it exists, that's just a thing that happens. There's a benchmark in Alaska at a 20-year starting point. I have yet to get a client that 20-year deal. So usually you're looking at 25, 30 years, 40, 50. Often that's pretty close to a life sentence still, right? I would also point, when we're talking about homicide, those crimes, any variation of homicide, have the lowest recidivism rate of any other offense, which people do not think is true.
That is not a well-known fact, no.
It is not, but it is the truth. And there are probably a lot of reasons for that. One may be the very lengthy sentences these guys get, so they're not getting back out. But I think the other hand, we see people they study the people who actually were released, and they have a lower recidivism rate than other offenses. And so the question is what, right? Is it greater supervision, right? Or is it the fact that homicide is one of those crimes that I really do think that just about anyone, if pushed in the right circumstances, could take another life. It is also a very rare occurrence. I don't think it happens even to the visage that people have in their head and the public of like the criminal, right? The hardened criminal. Even hardened criminals do not often recidivate when they have committed a homicide.
Yeah, that is super interesting, and really appreciate you bringing that up and bringing that to light, because as these high-profile cases get sensationalized and magnified in the media, people tend to overestimate the frequency with which this type of thing occurs and recurs, as you note. And in linking it with mental illnesses and addiction, they also tend to overestimate how frequently people with these conditions do things like this, and it can instill a lot of fear and judgment and stigma around those conditions when actually these are pretty rare events. So I appreciate you bringing that up. And speaking of which, thinking about the Reiner case, thinking about, based on what we know about his history, there are these sort of two elements of his psychological or psychiatric history that have been written about in news reports. I think the one that we know with more certainty because of the movie that he made about it with his father is that he has an addiction history. The other being a psychotic illness, which I think there's still a lot left to be discovered around that, but it has been reported in news media that he has schizophrenia. That was diagnosed a few years ago. I've seen more recently that being revised to schizoaffective disorder. So I think there's still a lot of speculation about what the nature of his mental illness, if assuming he had one or has one, which there's a lot of data pointing to a positive on that. What do you think are the elements of his case that stand out to you as a basis for an insanity defense, if that's the direction that his team is going to go?
Well, I'm just going off of what's been presented in the media, so I want to be careful, right? So the first thing that I think about with his case is, my experiences with my clients, and seeing that drug use often goes hand in hand with mental illness, specifically those who are on the schizoaffective spectrum. Right? I've often seen my clients and their families blame the drugs as the catalysts that cause the mental illness. And I do not know whether they are right or not. I know that I've talked to some experts who have given some credence to that claim that it can be a precipitating event. I also know that a lot of my clients who suffer from mental illness, specifically schizoaffective disorders, that they tend to medicate themselves. That the medications that they are provided for their illness, they don't like the way it makes them feel. They don't like the way it makes them look. They feel a loss of control when they're on these drugs. And for some reason, methamphetamine or heroin on the other end, right, they seem to provide some relief in the mind of the schizoaffective. And I think that the symptom that they're often struggling with is the internal dialogue of voices and the delusions, right? The inability to discern what's in their head and what's actually real. So I don't know whether that helps them or not. I do know that it sends them down a path, and often I see the mental illness become worse. So I don't know that it has long-term effectiveness. I do know that it comes with a lot of negative consequences. There's obviously the legal ones, but there's the health concerns, and then I think that it does exacerbate the mental illness, particularly when they're going on and off the medications that are designed to treat the mental illness. They develop tolerances for them. They become less effective over time as they go on and off of the drugs. So I mean, it's not much of an answer, just it's very complicated. Right? Yeah. And to say that, we can point to whether it's drugs or mental illness, I've always found that misses the point. They work hand in hand. And it's clear that what happened between Nick and his parents was obviously something that had to do with mental health to me. I know that people abuse methamphetamine for nearly their entire lives, and they abuse all kinds of illicit substances for their entire lives and don't end up killing someone. Right? There's something else inside of Nick that caused that violent action towards the people that he clearly loved the most in the world, the people that were the most on his side in the world, really the only people that stood by him through all of his substance abuse and mental health issues, which is, I think, one of the hallmark tragedies of people who have these mental illnesses, that the people that they hurt are often the ones closest to them. But I don't think that's adequately explained by the ingestion of an impairing substance. It's not to say that it doesn't happen, but generally when I see people who are just purely substance abuse addicts doing violence to other people because of the substance they are on, it is not the people that they are. That's not usually their parents or their sister or their brother. It's usually someone else in their drug milieu, right, for lack of a better phrase.
Yeah.
Their subculture. When you see it against parents, I tend to think mental illness. And I don't know if that's just, natural human nature to just sort of recoil from patricide and assume that the person has to be crazy, or if it is, educated by what I've seen. I'd like to think I'm speaking as a professional and not as a human being, but I think both inform the other, right? So
certainly,
that's what I.
Yeah, I mean, I think the research I've done on parricide cases pretty clearly reflects that the majority of those who commit parricide have mental illness first, like a psychotic disorder, and then a portion of them, at least half of them, maybe a bit more, have a substance use disorder, and a smaller portion of them were using substances at the time that the crime was committed. So it does seem more sort of primary predominant in their profiles, that there is a severe mental health disorder in the works, and then the substance use disorder aggravates everything because it can put them into such a state that sort of exacerbates the underlying mental health condition. So, and methamphetamine, certainly we do see that with psychosis. We also see cannabis use. Both methamphetamine or both stimulants as a category, so it doesn't even have to be meth per se, but stimulants and cannabis can worsen psychosis ultimately, even though people may take those substances initially as a means of self-medication or self-managing some kind of symptoms that are making them uncomfortable. As far as addiction and an insanity plea, I'm curious around whether addiction supports or really diminishes the basis for an insanity plea. Because something that you said earlier was that an insanity plea is in many ways an uphill battle. And I think you've already kind of shared in some ways why. But I would like to know a little bit more specifically, what do you have to demonstrate specifically in order for that to go forward or to yield a positive outcome? And how does addiction or substance use play a role there for better or worse?
So the presence of impairing substances in a case where you're running an insanity defense is probably going to be pretty common for the reasons we've already talked about, that it's just those are co-occurring disorders oftentimes. Whether one causes the other, that's up for the professionals to talk about. We're in, and I'm talking mental health professionals, obviously, to talk about. When I'm talking to a jury about it, the job I have to do is to present to them that the cause of the conduct was the mental illness and not the substance. Right? So you can see that makes the defense even more difficult, right? We're talking about the causation, right? And how do you establish with a jury? It's the state's job to prove that, my defense is not correct. They have the burden to disprove my defense. But the reality is, if I'm running an insanity defense, I'm having to convince the jury. I have to prove to them that this disorder exists, my client has it, and it is the cause of the violent act. That gets extremely complicated when you have something like meth on board, where the state will certainly present an expert who will talk about the effects that methamphetamine intoxication has on an individual, including the disregard of consequences, the increase of aggression, and the lack of impulse control, right? Impaired judgment. All of those things are legitimate reasons to disbelieve that someone committed an act because of a mental disease or defect, simply by the fact that there's other things that we can point to. And juries, like every individual who is exposed to the media, right, over the years, we have developed an opinion of what an insanity defense is. They're trying to get away with it, just essentially a skepticism from the public when it comes to someone saying, excuse my conduct because I was out of my mind, right? I didn't appreciate what I was doing because of this mental disease or defect. Even if I present a very credible expert to explain that this person does have this mental disease or defect, that it can and often does cause people to act in this way, and that this person specifically didn't appreciate the wrongfulness of their conduct. If the state is arguing that, yeah, but the person had meth in their system, and meth causes all those same things, it becomes very difficult to convince a jury that your reason is correct rather than the state's, when their natural inclination is to believe that drug addicts are violent and dangerous, and you give someone drugs, they're likely to commit a violent act. Which has always perplexed me because I, as a member of the public, believe that people with mental diseases or defects can commit violent acts without appreciating the wrongfulness of their conduct. It's the same analysis, right? But the public is very willing to believe that mental health can't be the cause when substance abuse could be the explanation, because that is something that they find more mentally palatable. Mm-hmm. I don't know if that makes sense.
Yeah, and that brings it into a little bit more of a volitional theory of why an act was committed. And that this may feel like a stretch, but there's so much stigma around addiction that's choice behavior, even though we understand from addiction science that at a certain point, when a person has used chronically and heavily enough, they don't have the same capabilities to use sound reasoning and judgment about their choices, and they experience a loss of control. But I think people hang on to this idea of like substance use is a volitional act. So if somebody used substances and that played a role in them committing a crime, then that was a choice that they made and they should be punished for it.
I mean, you definitely hear those legal perspectives from the state. I think defense attorneys tend, not because we're better people, just because of who we serve, right? We have a different view of addiction. But yeah, that choice thing, I think really plays a huge part in the minds of, the people who are arguing things in court and the people who are making the decisions based on those arguments. We're talking about jurors and judges, right? I think there is this, even though people who are in the criminal justice field have heard all of the data, have heard presentations from substance abuse providers saying that, addiction isn't a choice, it's a disease. It's something that people, don't have full control over, the same way that mental illness, they don't have full control over their decisions because they have this issue with their reasoning. I think the same thing comes into play with substance abuse, but we do treat that much more as a decision they made, right? Which I think misses the complexity of substance use with mental illness, right? We talked about that earlier, like they often go hand in hand. One may cause the other, one may exacerbate the other, but you are not often going to find a case where there is severe mental illness with persistent delusions that affect someone's decision-making, where they have not tried everything and anything to get relief. And they're not bound by rationality often. So finding anything that can help includes finding things that are terrible for you, have horrible effects on you and your family, and may exacerbate the outward symptoms that everyone finds terrifying. You may still feel, as the person who's ingesting those drugs, like it's making you feel better, like you are in more control, which is often not the case. And those decisions are the product of mental illness still, right? So
That's a great point.
It is very difficult for professionals to thread that needle with jurors, because you are forced to reckon with this idea that you have to prove that it is only the mental disease or defect that caused the act, right? I think of it more holistically, that if you're seeing this use of drugs that perhaps is a catalyst to the event because it's on board, I don't think that means that the mental disease or defect isn't the cause of the event. And again, we're getting back into the reason that insanity defenses are difficult to present to a jury, difficult to prevail on. You are dealing not only with the law, but with people's misconceptions of how mental illness works.
Really well said. And that sounds like that's at the crux of the uphill battle for anyone entering this insanity plea. And, more specifically from our conversation today, for the defense team, for Nick Reiner, to isolate the mental illness component of what was going on with him at the time that he allegedly committed these crimes, and link that specifically to all that unfolded. That sounds almost impossible, but
which is why they're not run very often.
Yeah,
why insanity defenses are just not used. I myself have never actually presented one to a jury. Gotten close, but it's never happened. Mostly because I'm afraid that my client will go with it.
So I'm wondering if you ever had, I guess the definition of a high profile case is different depending on the different jurisdiction where you're working. And I know you've worked in several cities, but did you ever have a high profile case like this in your area getting assigned to you?
Yeah, I have. It's not usually, so I have had homicides that get a lot of attention. I had one in Sitka that was, and as you said, like the level of media attention obviously varies, depending on the profile of the defendant. I was a public defender. I've never represented someone with means or notoriety or fame like Nick Reiner, and that has never come across my desk. But I have had the situational notoriety where the facts of the case make it of public interest. I had a case in Sitka where a man shot his girlfriend, and that, because of who he was in the community, garnered a lot of attention. And when you have scrutiny like that on your case, it makes all decision-making more difficult. It makes getting any resolution far more difficult. Pressures on the state go up considerably when the media and the public are paying attention. I don't know if rightly so. I think the state should treat every life with the same amount of dignity, obviously. But it makes it difficult for them to feel like they can just make decisions based solely on the facts of the case. And then there's the severe and serious pressure you get whenever you go into court and the room is full, the cameras are on, you're very aware that everything you say not only is going to be heard by this decider, but will be heard by the public, and then will follow your client everywhere he goes for the rest of his life. Right? It's a lot of pressure, and I think that it will be tough for Nick Reiner's public defender to handle that pressure, but I think that we all are able to focus on the client and just remember that when you're speaking to the public, you're speaking as your client. I have no doubt that will continue to happen. Obviously, Sergeant Jackson do a fantastic job of that already. So I think that's the major consideration is being careful about what you say and what you don't say.
And there's so much pressure. There's going to be so much pressure on Kimberly Green to say a lot of things, just as I've observed with Alan Jackson, who, very seasoned, experienced professional. So he doesn't seem fazed by it. But I can imagine the pressures there as, I mean, so much is on the record, so much is recorded, then it gets played and replayed in social media. So every word you say has to be somewhat measured, and nobody's perfect.
Right. Yeah. And I mean, the difficulty is removing yourself from that equation, right? Like not letting your ego dictate how you conduct yourself in front of the media. I think is difficult for some, and that's why I was giving so much praise to Mr. Jackson at the beginning of this interview. I didn't feel there was a lot of his ego in there, right? Obviously, he's out speaking to the media, and that always gets attacked as you're just trying to present yourself to the media rather than the client. But that wasn't what he said. It was a fierce defense of his client, which is what anyone who's dealing with the media should focus on when you're an attorney, is your client and not yourself.
Were you surprised at all about his withdrawal from the trial? Like, did you have a reaction to that? Or from the case?
No, I mean, yes and no. I was surprised to see someone jump out in a high-profile case like that, but conflicts happen all the time. And I don't know the details well enough to speak on it, other than generally, I think Mr. Jackson was the Reiner's family attorney before he was Nick's, and I imagine that may present some conflicts there, just based on what defense you might have to run. If there's any suggestion that the Reiners had anything to do with the circumstances surrounding their death that you have to talk about as an attorney, that puts you in an awkward position. I don't know the rules of professional ethics for California like I do Alaska, but there are things called the duty of loyalty, the duty of confidentiality, and any of those secrets or confidences that may need to be exposed to properly and vigorously defend your client puts you in a position where you have to withdraw from the case. I'm not saying that's specifically what happened here. I just am saying generally that's the sort of thing that could lead someone who has a relationship predating this criminal act with the family from stepping out of the case. And if that's the case, he did so very well.
Yeah, that makes a lot of sense. I think the one being floated all over the place is he wasn't getting paid or something like that. But I think like that's the most, sensational kind of interpretation of it. But I appreciate that you're bringing to light that there's so much more complexity with representing an individual as part of a family that you have had a connection with, and all that goes with that, and all the considerations lend themselves to many other possibilities, even though we don't know specifically which one explains it.
Yeah, and I think specifically him not getting paid doesn't make a lot of sense to me. He entered the case. He knew what the situation was financially when he got in. And I would think that someone taking that level of case on, either maybe he knew he was always going to get out of certain point. Maybe he knew that Nick needed representation right away. I can stand in for this period of time. And that could be a financial decision, right? But that might have been a financial decision he made going in. It is not likely, and I would say it creates some ethical questions if the situation is as the media has been sort of sensationally claiming, that he stepped out because Nick wasn't paying his bills. You just don't do that as an attorney. You shouldn't anyway. Take a case until the client runs out of money and leave. That is not good lawyering. And I don't think that's what happened. I think he entered the case, and if it was financial reasons, that was always the plan, that I will get you through this period of time through arraignment, try to address the initial bail considerations. But once we get you past this and I've given you some advice, we'll hand you off to a public defender. Right? Or what I think is more likely is he always planned to go the distance in this case, but ethical conflicts arose which required him to get out. I think that's probably what happened. The other possibility I threw out is also could be the reason. I really don't think it was that Nick just ran out of money. I don't think that makes any sense.
Yeah. No, the one I've heard floated a bit more is that the family didn't want to support his defense or something like that through the state of the parents. But again, every single headline is speculative. So
yeah, I mean that's also a maybe. I don't see him begging on familial permission for payment either. he's a pro, and it's pretty uncommon for your siblings, when you kill your parents, to stand by you. Even though they may very well know that there were other things going on that caused this. It's human nature to not be able to forgive or to accept the actions of a person who's mentally ill that took the most important people in your life away from you. That's just not a thing that I think human beings can square easily. And something I remember and remind myself as much as possible when I'm working in these cases and there's behavior out of the victim's family, which complicates my job, makes my job more difficult, and comes from a place of what I think is one, a lack of acceptance, forgiveness, but two, just a lack of understanding, right? And that's always informed by deep emotional pain, and pain that is as understandable as it is forgivable, right? It is something I completely understand and always forgive, even as it can hurt my client and be misguided. Now, I'm not saying anything about the family of the Reiners here. I'm not trying to say that their decision not to pay for, if that's what happened,
right,
Nick's defense, I understand that, I'm not trying to speak ill of them.
Yeah, no, that makes a lot of sense. There's so much background context of pain and suffering happening within an entire family and network of people who are impacted by a crime of this magnitude that I think people often forget.
I'm sure you've seen this yourself. When I've had these cases where I have a schizophrenic client or someone who's got schizoaffective disorder, and it's often their parents or a parent who stands by them no matter what they do. And I think you've talked about this in a previous podcast that I saw, where parents are far more likely to forgive, forget, not report when something happens to them coming from their child. And it seems that the siblings are not in those decision making, in that decision making process, one. Two, do not understand the bottomless well of forgiveness and acceptance that parents have, and are often, before the terrible event happens, frustrated with their parents for what they see as allowing the situation to continue, to not take steps to what I see as punish the person who has mental illness, right, or cut them off, to seek law enforcement intervention, to get them put into facility. They get frustrated that isn't happening before the violent act occurs, and once it does occur, it's all blame on the brother, the sister, the cousin, whatever it is, who took this person away from them, and just anger at the fact that nothing was done when they saw this thing coming from a mile away, right? And they are much less likely to support their sibling because they were saying maybe a year ago that, Mom, Dad, he's going to do something, right? You need to do something yourself to protect our family and protect yourselves. And it just seemed like inevitability to them. And then when it happens, it's unforgivable.
Yeah. Parents in this position are generally trying to help when they're insulating and protecting their loved one from certain types of consequences that they think they maybe can't handle. And maybe they're wrong about that. Sometimes they're right and sometimes they're wrong. But it's really hard to be in those shoes when you're not a parent. And it's also points to the importance of educating people around what the warning signs are of child to parent violence, which is something I've been working on, disseminating a little bit more broadly through my podcast and other means of communication, because understanding what can happen and what can unfold without, overestimating the likelihood of an outcome like what happened with the Reiner family, it could be, protective and life-saving for some people. I'll wrap up on that note. And I want to thank you so much for this really interesting conversation. I feel like I learned a lot about the laws around forming a defense for someone who has committed a serious violent crime, the complexity of the insanity defense, the potential outcomes of the insanity defense for the defendant, and like a really nice window into the rewards and the challenges of a career like yours. So I just want to thank you so much for being here today.
Oh, thank you for the opportunity. It was a really nice chat. I have thought a lot about the Reiner case just because of my experience. So it was really nice to be able to talk to a mental health professional about it. So thank you.
I hope you learned something valuable today about criminal responsibility, the not guilty by reason of insanity defense, all as it relates to the current case of Nick Reiner in the double homicide of his parents, Rob Reiner and Michelle Singer Reiner. I look forward to seeing you next time.